Good evening, everyone. And welcome to the BBA lecture series. The topic of today's lecture is fraud and insider trading in the Indian securities market. It's a topic that I personally find extremely interesting, and I'm sure looking at all of y'all, and it's something which is extremely relevant and something which is in fact finding more and more occurrence in our markets today. And today we are indeed fortunate that we have an absolute master and expert in this field in Mr. Sandeep Parekh. He's the managing partner at FinSec Law Advisors and a former executive director of SEBI. And he's agreed to address us today on how fraud, insider trading, and market manipulation impact India's security markets. So, may I now call upon our President, Mr. Thakkar, to just give some introductory remarks.
Good evening, everyone. About a month and a half ago, Mr. Parekh came to my chambers to give me a copy of his 5th edition of his book on the subject. And we discussed about this. Mr. Parekh is a member of our association. And once I tell you about his qualifications and studies he has made and whatever he has achieved, you will realize that he is a fit person to address us on this subject. And really, we are fortunate, as Naushad mentioned, that he has found time for us to give this lecture to our members. And let me tell you, as Naushad mentioned, that he has worked as an executive director of SEBI, and where he was in charge of legal affairs and enforcement department. He has been a faculty member of IIM Ahmedabad, Indian Institute of Management, Ahmedabad. We were just discussing, he has been a faculty member for last 24 years. He has been going there regularly to Ahmedabad to give lectures. He is LLB from Delhi and LLM from Georgetown University in USA. He is a licensed to practice in New York. He is a member of United States Supreme Court Bar Association. He is a member of Mensa. Mensa is a very select club of intelligent people. He is also a member of 999 Society. He has been recognized as a World Economic Forum Young Global Leader. He has published articles in Financial Times, Economic Times, and other leading Indian newspapers. He has been quoted in Wall Street Journal, The Economist, Bloomberg, and CNBC. He has the honor of speaking at the World Economic Forum's annual meeting at Davos, and additionally, he maintains an active blog titled Initial Private Opinion. Mr. Parekh also serves as a board member on HDFC Bank as an independent director. He has contributed as a member of the Cabinet Secretariat Task Force, which focuses on measuring performance in various ministries and departments of Government of India. Besides this, he is on an advisory committee of the School for Regulatory Studies and Supervision at the National Institute of Securities Market. With all these qualifications, I think I should not detain all of you much. I should not come between Mr. Parekh and all of you. So let us hear him. Thank you very much.
Thank you, Mr. Thakkar. May I just request, as a token of our appreciation for Mr. Parekh, we've just got a small memento that we'd like to present to him. If I could request Mr. Thakkar to give the memento. And we also have our famous Legacy of Law book on the centenary celebrations of our High Court. And now for the person you've all been waiting to hear, Mr. Parekh.
Thank you for such a warm welcome, and known Mr. Thakkar for a very long time and met him for the first time today. And thank you for the very long introduction. I hope all of you are not bored with that. What I'll try to do is I'll try to keep it, instead of a long monologue, you maybe make it 30-35 minutes and then make it a little interactive. I'll ask you some questions. Maybe you can ask me some questions, etc. A very quick question. How many people here would have traded in Indian shares before 1995? If you could raise your hand. Okay. Only one. Okay. Okay. That's interesting. So the reason I'm asking is because if you did, you would have gone through a lot of torture. Okay. And when I say torture, I really mean torture, because you would have paid money for good securities. You would have waited for 21 days, sometimes 4 or 5 weeks for the share certificate to come to you. You would then send it by courier to the company or the registrar of the company. There's a good probability that the shares would be stolen on the way, either on the way out or the way in, when they came back with the stamp saying that you are the registered owner of the security. In all, it took around 2 to 3 months for you, something for which you paid for on day one. And there's a good chance, and when I say good chance, I mean more than 5% chance that those shares would be either stolen or lost. And there'd be very little you could do about it. Once they're lost, you will file a civil suit and come here maybe and spend the next 10 years trying to battle for 25 shares. Also, one more factoid, just to give you a little perspective. If you try to raise capital, and when I say raise capital, could be rights offering, IPOs, etc., etc. Before 1988, we had a very different system. And again, I see the crowd here is reasonably young, so you probably have not even heard of what used to happen. But essentially, you had to go to a Babu in Delhi and say that I want to raise 100 crore rupees. The Babu will not give you time, so you schedule your time after 2 months. Then you have to convince the Babu that I want to raise 100 crores because I have a factory which is coming up which is worth 120 crores and I have 20 crores already set up. And then you have to convince the Babu about the price at which you would raise. This all sounds very bizarre, but this was true since independence till 1988. You have to convince a bureaucrat that you wanted to raise money and what pricing you would raise the money. And that is known as the merit-based system, like, in securities market jargon. 1988 we moved, of course, all of you know about the 1991 reforms. Securities market reforms happened in 1988 when SEBI was formed, not as a statutory body, but as an administrative body. 1992 the act was passed and SEBI was formally created as a modern securities regulator. So in 88 what happened was we transitioned from what I call the merit-based system, where a human being would determine whether and how much money you could raise from the market, to a disclosure-based regime. And I'm giving you this context because the opposite of disclosure is fraud. right? And that's the subject of the discussion today. Now, in a disclosure-based system, there's no human being who would kind of say, okay, this is good, this is bad, this is ugly. You come out with a prospectus, and what is contained in the prospectus is prescribed. There's a set of regulations which say, not just what you need to say, but even the font size is prescribed in that. Very, very detailed. A modern prospectus would have more than 1,000 pages on average. So very, very detailed about what the company does, what are the risk factors, what are the financials of the last 3 years, etc., etc. And then once you file it, again, SEBI is not vetting it. It just makes sure that you're fulfilling the norms which have been set. And after that, it's between you as a company and the investors. If you're able to convince them that you need that money and you're able to convince them that the price is right, they would buy it and they subscribe to the shares. And if they don't buy your story, they walk away. They say this is too expensive, or this doesn't look like a viable business at all. So no matter what price it is, I don't want to buy these shares, which means the issue fails. Okay. So think of going from a bureaucrat-determined system to a marketplace where millions of people decide whether or not you should be raising money, whether or not you should be setting up that factory, etc. So anyway, we've had one historical act which is still there, which is called Securities Contract Regulation Act, and I think many of you may be familiar because we've had the whole Harshad Mehta case. I believe some parts of it still continue to exist in this High Court. But that's kind of the historical act, and then you have the modern acts, which is the SEBI Act and the Depositories Act. In addition, there are some basic requirements which are prescribed in the Companies Act, with respect to capital raising, a couple of other issues. Now, these statutory provisions are just kind of 5 or 6% really, if you look at it in numerical terms, of the entire body of laws. It's all delegated legislation, which means SEBI gets to write the law, they get to interpret the law, they get to enforce the law. Okay? So they're really on all sides, and this has been discussed in a Supreme Court case called Clariant versus SEBI, where Supreme Court did not kind of say it's not a good practice, but they just noted that all the three executive, judicial, and legislative powers are contained in the same body, which they found odd, but they did not kind of say that this is not kosher. And that's what SEBI really does. So they get to write the laws. Like I said, 95% of laws are written by SEBI. It's interpreted and enforced, which means the investigations are done by SEBI in-house. And finally, there's a quasi-judicial order which comes out from SEBI, which used to come to this court, but for now more than 1.5 decades, it goes directly to the Supreme Court. And of course, they don't have to follow civil procedure, they have to follow principles of natural justice only. Now, coming to kind of the topic today is fraud, and can I just see, I think all of you understand the tort of deceit, right? So what are the elements of common law fraud? Any ingredients I can hear? Most important, mens rea. What else? Inducement, okay, fine, mens rea, connected to mens rea. But anything else? What else? Key elements of the tort of deceit. Okay, benefit, personal benefit. What else? The most important one. Exactly, deceit. And deceit again, deceit is kind of more legally, I would call it misrepresentation. Okay, and it has to be material misrepresentation. Now, what is material will of course depend on the facts. If you lie about your age in a prospectus, normally it's not material. But if you lie about your age in a prospectus because you have committed pension fraud, then it suddenly becomes material. So it depends on the context, what is material, what is not material. So mens rea is obviously key. Misrepresentations are obviously key. It has to be material is also key. Damages, which you mentioned, is also important. One thing which we missed is causation, and that's actually very important in the context of securities law fraud. And all of us understand basic causation, that A led to B, B led to C, and therefore A caused C. But there's something known as loss causation, which is very specific to the securities market and very important. And I can explain it with an actual case, which is actually a US case, where a person raised money, borrowed money from a bank, and the bank actually could not have given that money, because under margining rules, which is, you know, whatever the regulator said, that under the margining rules, you cannot lend money to this person. So anyway, the bank lent the money erroneously, and the person took the money, and without, of course, telling the bank, invested in some useless securities. The securities value fell, collapsed, lost all the money, and he goes to the bank saying, you caused my loss, because you could not have given me this loan. Had you not given me this loan, I would not have invested in the bogus securities, and I would not have lost money. Okay, just think of it. Transaction causation, A caused B, B caused C. So transaction causation did exist in this case, but the court said, no, that's not good enough. You need loss causation, which is the loss was caused by own foolishness of investing in the securities, not caused by the fraud which is coming from the bank. So these are, again, you know, nuances which have developed over case law about what is required in securities law. But again, you know, it's very close to the tort of deceit. It's not, if you understand the tort of deceit, you probably understand 95% of it. So what is this 5% that you don't understand is under the tort of deceit, you need reliance, which means you have to rely on the misrepresentation, right? And that's, again, you know, been well understood for 200 years that unless you actually rely on the misrepresentation, you can't claim damages. The regulator can still go after you, but if you are injured by the misrepresentation, you can't sue for damages. And again, very interesting US court ruling, which said because markets are efficient, because you have millions of people who are meeting in the markets, in the securities market, your NSE and BSE, every misrepresentation converts itself into the price. So let's say the true value of a share is 100 rupees, and you have inflated your financial numbers, and it was actually trading at 110 rupees. So 10 is the fraud cost. Okay. So if there's a prospectus, similar example, and you have inflated the number, your financial numbers, and you sold securities for 110 when the actual worth is 100, then simply by looking at the price of 110, you have actually relied on the prospectus. And you don't have to prove that you actually read footnote number 484 on page 630. And that's why, you know, there's been a shortcut which has been devised by the courts, saying that so long as you relied on the price, which everybody does, nobody buys things without looking at the price. And therefore, the reliance element is, you know, there's a presumption of reliance, really. And it's a rebuttable presumption. Again, there are lots of cases where they've said the market is not efficient, and therefore price doesn't, you know, the information does not convert into price. Example, small cap stocks, where there's not a lot of trading. Okay. There you would actually have to, if you're trying to sue for damages, you'll have to show that you read that 1000-page prospectus and you relied on footnote number 634 to your detriment. Again, those are rare cases. Usually, you know, there is the presumption of reliance that you acted rationally. So this is kind of the one difference between common law tort of deceit and fraud in the securities market. Why? Because the securities market is very hard to prove anything, because there are literally millions of people who are buying and selling from each other, right? The definition of fraud and insider trading is really given in section 12A of the SEBI Act. And again, you know, this basically kind of just two sentences out there. And those two sentences are pretty much the same as the tort of deceit which we just discussed. And it's also copy from the US law, which is also known as Rule 10b-5, which again, people who do securities law work would know it quite well. And which as I said, is kind of almost a replica of the tort of deceit. Now, fraud has the elements which we discussed, right? So, you need mens rea, you need material misrepresentation, damages, and causation. Excuse me. Insider trading, which I'll discuss shortly, is something which actually came not out of fraud. It came out of a breach of fiduciary duty, and which is, may sound a bit like fraud, but it's not always the same. And breach of fiduciary means that you violated your duties of care, diligence, and loyalty. Now, all of us are lawyers, we know fiduciary duty as it applies to lawyers, it also applies to intermediaries like brokers, investment advisors, all the other financial intermediaries. The origin of insider trading really comes from the fiduciary duty of directors, that you have access to information about the company. Imagine financial numbers. Again, if you see old cases, you will see all of them are oil and gas cases, where the directors have discovered some oil and gas reserves, before that information was made public, they kind of bought large number of shares, and then as soon as the information was made public, they sold all the shares. So all the 100-year-old cases will all be oil and gas cases. So that doesn't sound like fraud, right? We just discussed what the ingredients of fraud are. That really doesn't sound like fraud. So it really came from the director's duty. First, to the company, they should put the interest of the company ahead of their own interest. By trading, when they have information which is not in public domain, they are breaching their fiduciary duty of loyalty to their shareholders, because they are supposed to, by trading in shares while others don't have the information, they're acting in breach of fiduciary duty. And that is the, again, historical background of insider trading. And it's been almost 120 years since the first case was evolved. That time it was not called insider trading. It's a relatively more modern term. And again, it's kind of a outcrop from US case law. There's no law against insider trading till 1934. 1934, that was kind of the 1991 moment for the US in terms of what they call the New Deal. Entire set of the antitrust laws came, securities laws came, lots of new laws came in the US. And again, they didn't have the transition we had. I told you about the merit-based system and the disclosure-based system. They didn't have any system at all. It was a vacuum. So something that we take for granted for all companies is the annual report, right? There's no requirement of an annual report in 1932, 33. It was a complete free-for-all. One of the biggest fraudsters was actually Joseph Kennedy, whose son was, all of you know, the president of the US later. And he was actually made the first SEC chairman, even though he was a big fraud, because somebody asked the president, why did you get a fraudster to head the regulator? And he said, it takes a thief to catch a thief. And actually he was a good, good regulator. In 1934, there's the Rule 10b-5, which I mentioned, to outlaw fraud. Since 1934 till today, the US has chosen not to say that thou shalt not commit insider trading. There's no law against insider trading. So it has actually been interpreted to come out of the Rule 10b-5, which is the rule against fraud. And of course, there have been lots of legislative actions attempting to bring a special law on insider trading, but they have not. In India, we've chosen a completely different path. We have decided to not only define insider trading, but we've gone to extraordinary lengths to create all kinds of deeming fiction, right? So your immediate relatives are insiders. You're deemed to be insiders. So to give an example, my spouse trades, and I'm on the board of directors of HDFC Bank. She trades in HDFC Bank. There's a presumption that I passed on information to her, right? Now, it's not just spouses, which is where it sounds very obvious that obviously the information problem, but it's a much wider circle, including lawyers, bankers, brokers, all kinds of, around 10 relationships are deemed to be insiders. 2 months back, SEBI expanded the list of relatives, so not just your spouse, but your father-in-law also becomes deemed connected, and your first cousin would also be deemed connected, etc. Now, why is that important? Okay, so before I come to that, there's also a list of deemed material information. So, a company is supposed to come out with all kinds of material information, put it out in public domain, right, on a routine basis. And again, recently SEBI expanded the list of things which have to be put in public domain, right? So I'll give you one example which was not there and which came is, if you start a forensic audit, if you think there's some fraud, not on finding of wrongdoing, but even on initiation of the forensic audit, you have to report it put it in public domain. Okay. So they have a list of, there used to be a list of 6, they've added 11 more things which are deemed to be material information. And if any part of that list is used for trading, which means before it's put out in public domain, then it's considered to be insider trading. And again, like I said, if you're connected to somebody, your bank or merchant bank, etc., and that person trades, SEBI doesn't have to show that I passed on information, okay. Which it would have to. It would have to show an actual conversation between two people, which is a difficult standard, right? How do you prove something which happened in a closed door? Instead, the law has become kind of, at least for the deemed connections, it's become impossible to rebut. Which means if I'm connected to somebody, if I have a relationship, let's say my merchant banker, I'm chatting, or my lawyer, okay? I'm giving an opinion about some random thing, and I talk to somebody in the company, there's a presumption that that person gave me the quarterly numbers of the company ahead of making it public. Now think of it, just like it's very difficult for SEBI to what goes on behind a closed door, it's impossible for me to disprove that I did not get the information, right? And we see that a lot as securities lawyers, that a lot of innocent people get caught up in insider trading. They can't disprove it. Just to take my own example, I don't touch stocks at all, right? Because I'm talking to companies all the time, and there's a presumption that any trade that I take place is connected to that person, which of course I have no idea. So what I do is I only trade in mutual funds, right? Because I can never disprove it. I'm talking to somebody in the company, I bought 100 shares and there's supposed to be a connection between the two, when there isn't. And it's impossible for me to prove unless I put a kind of a camera on my head 24 hours. So, in India, like I said, we've taken a completely different trajectory of fraud in one direction and insider trading in the other direction. Again, let me give you one more example to kind of tell you the difference between the classical definition of insider trading, which came out of the fiduciary duty. Imagine two directors are sitting in the back of a taxi, okay, and they're not obviously trying to tip off the driver, the taxi driver, and they're talking about quarterly numbers which are not yet published, etc. It's assume that it's unpublished by sensitive information. The driver's a graduate of IIM Ahmedabad, understands financial numbers, and trades based on the conversation which is going on the backseat of the taxi driver. Now, under the classical definition of insider trading, is this insider trading? The answer is no, because there's no kind of information which is being passed on, there's no fraud, there's no, neither the taxi driver nor the two directors are trying to, exchange information in either bad faith or illegally or fraudulently or, or even immorally, right? So under US law, this would not be insider trading. Indian law is a pure standard of possession. So if some paper falls out, I pick it up and see quarterly numbers and I trade, I'm liable. Okay. So we've kind of gone to the other extreme in terms of any possession of information, no matter how honestly procured, would amount to insider trading. Companies also have a high standard now. So not only when you pick up the paper you're liable, but probably the company is also liable for not keeping the paper safely. Okay. So there's a whole standard of keeping a digital database, making sure that you have a restricted list of people with whom you share information. If you're doing quarterly numbers, not more than whatever select group of people in the finance function, audit function, 2-3 kind of keep the circle as narrow as possible and list it out in a time bound timestamp manner. So if SEBI wants to do an investigation, they know that okay, these 25 people had access to the information. They start kind of matching it, and again, it's fairly easy if you think of it. SEBI has a list of everybody's PAN numbers. So every time you and I trade in one share of Infosys, it goes into the surveillance system. So when when there's any trade which takes place, the way they investigate is they will look at who are the largest traders. Let's say there's a big merger event, and as soon as the announcement is made, the price of the target company goes up 20%. So SEBI will kind of go back 3 months and see who are all the people who bought more than 5,000 shares in that 3-month window. And they start making phone calls that how are you connected to the director, how are you connected to the auditor, how are you connected to so and so forth. And then of course they make a case, and like I said, the deeming provisions help a lot because everybody's kind of plugged in, there's an audit trail, there's a kind of connection, every time there's the database which I mentioned, director's spouse, director's father-in-law, mother-in-law, everybody's PAN is kind of fed into the system. So it's actually reasonably easy with the kind of strict laws plus the digital footprint that we all leave behind. In fact, there's one case where SEBI kind of triangulated with the position of the phone. So the fact that my phone is lying there can be triangulated to within around 20-30 feet. And there's a famous SEBI case where the person who was doing fraud, he'd taken a SIM card in the name of his driver, and SEBI said, based on your movement, that's not your driver, that's you. And it's a very interesting case, Pyramid Chimera, where they've gone into it. Excuse me. Now, let me just kind of end with 2 cases on insider trading, and then open it up for questions. The first is a US case, the second is a very reasonably recent Indian Supreme Court case. The first is very interesting because it kind of talks about what is and what is not insider trading, and it's not always intuitive. Okay. So there's an analyst, business analyst in New York who kind of found some big fraud in a blue chip company. So what does he do? He goes to the Wall Street Journal, says, big fraud, blue chip company, please write an article about this, unravel the fraud, tell people about it. So he gets laughed out of the journalist's office. He goes to the SEC, which is the regulator, twice, again gets laughed out of the regulator's office. You must be crazy, it's a blue chip company. So what does he do? He's an analyst, so he has a newsletter which he sends out to his list of clients, and he writes a whole 5 pages on the fact that he's spoken to employees, the numbers are fudged, the factories are not real, this, that. And what happens is, of course, all his clients sell the shares of that company, short sell the shares. Price falls, and then of course there's investigation. They find out there's actual fraud. And guess who the regulator comes after? The analyst. For what? Insider trading. You spoke to employees, ex-employees, you got inside information, you tipped off your clients about the fraud, and therefore it was just a rap on the knuckles, but they went after him. And the even though it was a rap on the knuckles, he went all the way to the US Supreme Court, and US Supreme Court said there has to be fraud involved. It can't be, this is not a case of fraud, this cannot be insider trading. So they said unless there's kind of mischief happening in the tipping of information, it's not considered insider trading. Fast forward to 5 years back, Indian Supreme Court, very interesting case. This is called Balram Garg, is based PC Jewelers, that family, Delhi-based family. And so there were these basically family members who were living in the same compound. And SEBI built out a case saying that, you must have, again, they were not even deemed connected. They were not immediate family because the cousins and all that. So that time they were not deemed to be connected. So SEBI said that you were living in the same compound, you must be chit-chatting with each other, you must have given each other information, and you sold shares before good news, and therefore you must have committed insider trading. Now disprove it. And again, went all the way to the Indian Supreme Court. And the fact is very interesting because this two facts, additional facts, which are very interesting, is one is the family members didn't get along. Okay. They were not even on talking terms with each other, which SEBI presumed to be connected to each other, saying you live in the same compound. And again, they kind of showed it based on litigations which were going on between the two factions. And the other interesting fact is, before good news, this person sold shares, did not buy. So what is the logical thing that you do, right? You have good information, you find oil and gas, you buy before the price goes up, right? In this case, it was actually a sale before good news was put out in public domain. And SEBI's defense was the law does not say which direction the trade should happen. And it took the Supreme Court to say that's like illogical and stupid. And they didn't say it, call it stupid, but in other words, they kind of said that this makes no sense at all. If you sell before good news, it can never be insider trading. And again, that's anybody who's interested in insider trading should read this case. It's kind of what I would call a master class in insider trading. You don't need to read any other case. Before I end, again, just to say, I think the laws have become very constricted. So it makes a lot of honest conduct difficult. And I'll give you one more example, which we face when we advise clients. Private equity wants to invest in a company, they will normally do a due diligence, right? Now, due diligence is the classic access to inside information, which is not in public domain. Why would you do a due diligence if everything is already on the stock exchange's website? Your past quarterly numbers are anyway there. So you obviously want to dig a bit deeper, right? And based on your due diligence, you make an investment. And that's almost like the definition of insider trading, that you have access to information which is not in public domain. You trade based on that information, which happens in all these investments. And again, people are kind of very overcautious in terms, because, like I said, there's an exemption which is for legitimate purposes, but it's a very abstract exemption, and therefore people go out of the way to sometimes they put the information on some corner of the company website. They do all kinds of jugglery so that nobody can then later accuse them of insider trading for what is obviously pretty honest and standard standard deals. So with that, I'll, like I said, I don't want it to be a long monologue. I just thought I'll give you a flavor of fraud and insider trading, both in the Western context and Indian context, and a little bit of comparison. There, like I said, fraud is very similar, but insider trading is quite different from the US system. So with that, I'll happy to take questions, comments. Yeah. I think because I think it's recorded, so speak it at the mic. There's only the reply. So this is something which I didn't touch upon. This the name of the regulation is fraudulent and unfair trade practices. So Dabba trading is considered falls under unfair trade practices, and this comes out of the 1956 Act and not SEBI Act, which prohibits any transactions outside of a stock exchange. Okay. So you and I buy Infosys shares. I mean, if we are friends and all, we can sell to each other. But if there's an organized system, and again, it's not very common now, but 10 years back it was, if you went outside Ahmedabad Stock Exchange, it didn't happen too much here. But outside of the old stock exchange, which are all defunct now, of course, there used to be this Dabba trading, which is kind of an informal market where people meet and buy and sell. And very often they're not buy and sell transactions, they are kind of notional trades. So you agree to buy a equivalent of 100 Infosys shares, and then after a week it gets rolled back. So if the price goes up, one person pays the other person. And so it's kind of netted off without actual delivery of shares. Again, I'm not sure there's something inherently immoral about it, but the 1956 Act prohibits transactions outside of stock exchanges. And again, we've kind of a modern equivalent is there are a lot of these companies which help buyers and sellers meet for unlisted companies. Okay. And you'll be surprised to know that the definition of securities under the 56 Act includes all public limited companies, not just listed companies. And therefore, normally SEBI has domain only on the listed space. But in this case, SEBI has domain even over unlisted public limited shares. It does not have over private limited shares. And therefore, SEBI sent out notices a couple of years back to many of these electronic platforms which were helping buy and sell, like National Stock Exchange shares, right? Or any of these other companies which are not yet not yet listed. But so SEBI has been cracking down on that. And again, outlawed in 1950, not sure there's anything inherently immoral about it. Obviously not very safe, because other person runs away, there's nothing you can do about it. Yeah.
So I have two sets of questions.
Sure.
So the first set of questions involves, you said the deeming thing is there, where your relatives, even far off relatives, are also deemed to be insider. So with respect to your friend having certain information and trading based on that, will your close friend be also considered as insider?
Not deep.
He wouldn't be considered that.
No, so
okay.
not deep.
Okay. One more thing.
But the phone calls are made between two of us. We are friends. A lot of I call you thrice a day, especially before that periodic the quarterly numbers come out. Then SEBI can draw an adverse inference.
But he wouldn't be
But will
deemed
not be
to be
deemed.
considered as insider. Okay. One more thing. Suppose you run a company or you have an organization which is a separate legal entity on its own. So you, as you said that since you interact with so many people on a daily basis, so many companies, so you refrain from doing that. But rather what you do is you do the trading in stocks through this another legal entity which has significant control under you. So will that be...
That's deemed.
That
So directors, promoters are deemed to be connected to the company.
The company through which you
Yes.
do insider trading, that company would be also deemed to be...
That's one of the list.
Now coming to the second set of questions which I have. So you said that you directly don't invest in individual stocks, but you rather invest in mutual funds. So suppose you know that HDFC Bank is going to outperform really well, or along with maybe ICICI Bank and Axis Bank. We all know that is these three banks comprises heavily of Nifty Bank. So based on this, if you particularly buy Nifty Bank's mutual fund, will that be considered insider trading or not?
No, that's not considered insider.
That's not considered.
See again, essentially if you were able to break the causal chain between information and the trade, and this is kind of considered to have, I'll give you other examples of breaking the causal chain. I'm let's say connected to you, okay? So you kind of, my father-in-law, whatever deemed connected. Excuse me. And you are able to show that you sold shares even though there's a deemed connection, because my wife was getting operated for a heart surgery. Okay, so deemed connected. You're a member of the board of so and so company. I have sold shares. I have broken the causal chain. Why? Because I needed the money for the heart operation and not because of access to information. So there are multiple ways to break the causal chain, and this operation is one example. There's something known as a trading plan where you agree to sell 5,000 shares after 6 months, every month for the next 3 years. That's again breaks the causal chain. Even though I have access to the information, my trade is already been pre-planned, and therefore I'm breaking the causal chain. So that's.
But doing some kind of speculative trade through mutual funds like this, where you may know that this information correlates to Bank Nifty going
So
up,
I mean,
this wouldn't affect anything, or maybe you speculating on futures
it
and
breaks the causal
options.
chain. I mean, not 100%, but it breaks it. So I mean.
Okay. Thank you so much, sir.
Yeah.
Wait.
Doing the investigation, they are taking the law, and the Supreme Court, as you just said, has given a obito dicta.
Yeah.
They are not said.
That's
so,
all.
whether this was in a constitutional bench, do you suggest that this case goes to the constitutional bench in order to? I'm a criminal defense counsel, so when I get a client, I want that he should be given proper defense. So was this in a constitutional bench, or it has? I think that it should go to the constitutional bench.
I totally agree.
Challenge the constitutional validity of that ruling.
I think so. I think it's very important, and again, based on my daily experience, I can tell you it's kind of, it gets, this concentration of power does cause problems. I'll give you a very simple example. Now we have 2 Supreme Court rulings, one called Reliance Industries, second called Takano, which have completely, it's completely blanket in terms of what has to be given in inspection. Because, before you file your reply, you need access to all the information SEBI has relied on, and they don't give it. Despite 2 Supreme Court rulings in almost every case, SEBI will not give you that information. How many people have the financial capability to challenge that fact? And again, 95% of clients don't want to fight every single thing, and they're fighting the main case with SEBI. They're now for inspection also they'll fight. So the fact is, I mean, so much of concentration of power is never a good idea, and unfortunately, people have not challenged it. But I think it's ripe today to yeah. Yes, please.
Yeah, good evening, sir.
One second.
Yes, yeah.
Okay. Here's the mic. Let him.
Yeah, my question is pertaining to the what the regulator is looking for, the accountability of banks, because in all kind of these trades like institutional buying and all, the top hierarchy of the banks also act as a accomplice. In most of the cases we have seen in the past scams and all, but there is no accountability for bank. It is always viewed as a victim, and the government bails out for these banks for their wrong decisions because they are playing with public money anyhow. But what the regulator is doing, at least for these private bankings, there has to be some regulation on that, or if the trade goes good, they enjoy. If the trade goes bad, then they go for bailout and all these things. There has to be some accountability for banks also.
No, so I think there is accountability for banks. All of you know of the Chanda Kochar case. So she went to jail. I think she's out currently, but there is accountability for senior management of banks for wrongs that they do. They are public servants, so under the Prevention of Corruption Act. So they are all bank employees actually, even though they have no public monies at all, except for deposits. But they still held to a much higher standard compared to other private limited companies and privately owned companies. So, the fact is there is significant accountability, and RBI is kind of, again, since I sit on the board of a bank, I know everything is kind of it's seen very closely by the RBI, especially for the big banks. They may not be looking closely at the cooperative banks and all the regional rural banks and stuff, but if you look at the top 8 or 10 banks, they actually look at the video recordings of board meetings. That's the extent to which they kind of look at. They look at, compensation is capped. You can't pay anything that you like to the MD of the bank. So there are lots of, I think, checks and balances in banks, I would think. Yeah.
Hello?
Yep. I think it's working.
It's working. Okay. So my question is more for a little background about me. I'm into the capital markets. So my question specifically with regard to the interim order on Jane Street was.
I can't talk about I represent.
Oh.
Sorry.
Okay. But would that amount?
I really can't answer it. Sorry.
Okay. With regard to another question
sure.
is with regard to IndusInd Bank. Now the CEOs there, they systematically, as you said, in a way, they sold off shares knowing fully well that there were errors in terms of the derivatives portfolio. So now, in this case, he's already entered into a plea deal with SEBI from what I understand.
No, so there is a system of settlement in SEBI where you pay kind of a penalty. It's a bit like compounding. And you pay the amount, and usually it's a much higher amount compared to the penalty. And without admitting or denying guilt, you kind of settle. And that's been around for 15 years. You may or may not like it, but the fact is it kind of reduces the bottlenecks.
Now,
right? And I mean, the Western standard, 99.9% of SEC cases settle. Today, despite settlement, we still have, again, I looked at the annual report which came out a few weeks back. We have a bottleneck of around 10 years of pending cases at SEBI despite this. So, I mean, I'm a big votary for having settlement. IndusInd Bank, again, I don't represent them, but if I were, I mean, the way I would defend myself would be, and that's true of all banks, because a third of your compensation comes by way of ESOPs. And every time you exercise ESOPs, you have to pay tax. Okay. So any bank senior management is forced to sell shares on a monthly or quarterly basis. So again, you know, if I were defending them, I would say that there's no breaking the causal chain. That I was selling it every quarter for the past 15 years, right? But I don't know the facts of this
now,
case. But
just to follow up with this, now you mentioned also that SEBI is well aware of everyone's PAN, and there is that aspect also. So ideally, in its capability, it can identify losses suffered by market participants, like for example, retailers. Now, rather than transfer the money when penalties are imposed and everything into the investor protection fund, why not just refund it to those people? Because it's not that the NSE and BSE don't have a tracking system.
so the penalty does not go into, penalty goes to the Consolidated Fund of India, number one. Number two, the money which they collect, if they're able to refund it, they do it. I mean, the classic example is Sahara or Pearl Agro, where, you know, there's this retired Supreme Court judge who's overseeing a panel which is supposed to find out the victims. Again, there are like tens of millions of victims, and therefore, you know, you can't really find all the people who lost 100 rupees or 500 or 1000 rupees, you know. They will have to be, if you can find it also, it has to be cost effective, right? If the cost of finding a person is 300 rupees and you're paying him 300 rupees, it's kind of not worth it, right? So there are many cases where you're able to identify victims, money is paid back. In insider trading, obviously, you just think of it this way, even if you do insider trading of 100 shares, you are not shortchanging the person who's sold you those 100 shares. You're shortchanging the entire sell side of the market. There's something known as a chronological privity, which, you know, we can discuss offline.
Okay, thank you.
Hello, sir.
I'm waiting for long. This is yesterday's games, that one? This is yesterday's replay. Okay. So those of you who couldn't hear him yesterday, those who saw the news, actually today morning, happened yesterday. There's a person who runs a course on options trading and apparently made 500 crores over the past several years, teaching people how to make free money, which of course doesn't exist from the stock market. Option trading, as all of you know, is like really big and So, to answer your question, is it illegal or not? There are two answers. Yeah. So this gentleman was not doing that, but I mean, there are lots of them who do that. This person was selling options trades and stuff like that. Okay. So specifically, two problems with this specific gentleman. Again, first is if you provide any investment advice, okay, you have to be registered as an investment advisor. Okay, that's the first blanket kind of automatic problem this person's in. Right? Some of them are actually registered as investment advisors or research analysts. So the second charge would be, which will have to be proven, that fraud occurred. So again, it'll go back to those elements of material misstatement. Your second question, or the third question really, is with respect to where kind of people are making specific recommendations of stock based on some kind of mischievous payments coming, let's say, from the company or its promoters and all that. Again, the problem is, of course, it's illegal. No, I mean, no two views about it. The problem is of bandwidth, which is SEBI can't go after. And with earlier, I could talk to you, I could call 20 of you and talk to you. But now with kind of social media, Instagram, all that, you're able to reach out to millions of people. Many of these people have millions of followers, and therefore, they have WhatsApp groups and stuff where they're able to communicate literally with tens of thousands, millions. They have YouTube hits of 100 million and stuff like that. So your ability to reach out and commit fraud has increased astronomically, and not just your ability to reach out, but the number of people who are doing it is also huge. I mean, could we? My kind of ballpark number would be over 1 lakh. And I think, like I said, it's a bandwidth problem. I don't think SEBI can go after 1 lakh people saying that you are committing fraud. And therefore, you will see cases. Almost every week, you will see one case coming out of SEBI saying that you're committing fraud, you're giving this illegal this thing. There's a very strong, actually, not just the SEBI, but there's a advertisement code also, which is quite strong, which says that if you take any money from somebody and you make a pitch without disclosing, that's kind of a second violation besides fraud.
Excuse me, sir. Pratim Ronikar here. I wanted to ask you about insider trading outside of shares, like maybe in currency derivatives, and what are the challenges you face while regulating?
Okay. So, I mean, currency, I don't think we've. See, first of all, we've had instances of fraud not in currency. I don't think there's been, because those are very, very liquid markets. It's very difficult to manipulate currency. We've had a very big international scam which originated in London called the LIBOR scandal, where like we have the Indian interest rates set by RBI. Similarly, there's kind of a global benchmark called LIBOR, which is now outlawed, by the way. I think they've run its course. It's no longer a benchmark, but that was a benchmark based on which interest rates would be. So, let's say you take a mortgage in, whether it's in London or New York, it was all benchmarked to LIBOR. So if LIBOR fell, your actual EMI would go down. And that was actually being manipulated by kind of a handful of big banks, really big banks, and that became a big scam. Broadly, SEBI's remit is restricted to the securities market, and that can have a lot of kind of complications. Example, currency that you mentioned, unless the currency is being traded on the market, it would not be securities. Therefore, SEBI would not have remit on it. Right? Currency derivatives on exchange would fall within SEBI. Yeah. So anything which is on exchange, but again, it's like an iceberg, right? So whether it's currency, all these, most of the derivatives are not traded on exchange. Only kind of, things like interest rate, currency, 95% of these are traded off the exchange. So by volume, actually, it's very, very small what you see on the market. So it's a what we call OTC market, over the counter market, and that's huge. I mean, and it's between big boys only. So I mean, usually trades would be 5,000 crores, 10,000 crores, and stuff like that, and those are bilateral trades by way of contract. So it's called the BCD market, bond currency derivative, and they're kind of interlinked. SEBI is trying to bring a lot of the bond market onto the platform, but again, they've been trying since for the past 25 years. NSE, National Stock Exchange, is actually the first segment which opened was actually the bond platform. It failed in 6 months. They started the equity market. But so yeah, for 25 years we've been trying to bring the bond market onto the exchange without success. And again, maybe we can discuss why. That's an economic question. We can discuss it offline.
Good evening, sir. Kushal this side. So I have two queries from you. I just want opinion and suggestions. So what I see, it would be not great to compare the US and Indian laws, but since I could see that US laws are more of the curative measures, the establishment of SEC, FINRA and SIPC. And in India, it is more of the preventive measures, that is after the LPG, that is SEBI. And what I could see that most of the SEBI is the centralized regulatory, but in US there is a decentralized system. And what I would be more talking about the SIPC, that is the investor protection, for the investor protection. In India there is no such other regulatories that are being made under SEBI or after the SEBI. So I just need a suggestion or opinion that it should be made or it should not be made, or what the consequences, because it is more beneficial to the US. And after the inception of SEC, that is in 1934, and the SIPC was made in 1970, that is after 35 years. And now India has realized that India's securities market has realized after 35 years of SEBI establishment that there is a major cases arising of the insider trading. So what would be your opinion or suggestion that?
No, so I think SEC and SEBI are nearly identical. I think the only difference is SEBI falls under the center in India, whereas SEC does not have technically a monopoly on securities regulation. So you actually have 51 securities regulators in the US. But I think broadly it's become completely federal, because they've allocated that if it's small business, small amounts which are raised, then they many of the filings, IPOs are filed both with the state regulator and with SEC, stuff like that. But broadly, I would say SEC and SEBI are almost identical in nature, except one big difference is SEBI doesn't have separation of powers. Right? They have to collect the evidence and they have to go to a district judge to prove the case. The first time they got administrative powers was actually very interesting. Indian person, Rajat Gupta case. So they just got the power to actually decide cases internally. And Rajat Gupta challenged it. He went to a court saying, I don't want SEC to hear, I want the court to hear. And anyway, the rest of the story is he went to jail after that. But that's a different story.
Okay. So recently, the SEBI has been easing compliances, IPO compliances for the IPO norms, and there was a recent that related party transaction easing compliances for the big firms, for the big companies. So would that be viable? As if I see that it matches the standard compliance system all over the world, as if easing that, but it would be burden to the Indian legal system, or what is the opinion?
So maybe I'll take this question offline. It's a very specific question on related party transactions, and it's still a proposal in terms of easing it. So maybe we can take it offline if it's too technical for everybody. Let me just end by saying that I did an article for Economic Times a few months back where I compared the definition of fraud under Rule 10b-5, and there's kind of pretty much nothing else. So it's 140 words versus Indian definition of fraud and insider trading, which are two separate regulations, which runs into 24,000 words. Okay, And that's only the regulation. I'm not even talking about circulars and other kind of things. So we have actually very much departed from the common law in terms of principle-based common law system, where we want to define every single thing about these things, which makes it rigid and gives you false negatives and false positives. Whereas with those 140 words and nearly 100 years of case law, it's a much richer discussion of what is fraud and what is not. So I'll end with that. Thank you all for being here.
Thank you, Mr. Parekh, for clearly what was an extremely interesting and engaging talk which we all had. And I think testimony to that is just the number of questions that the audience, in fact, had asked you. So with this, I'd like to thank everyone. Thank you all for spending your time also with us on a Friday evening. There are some tea and snacks. So this concludes our evening's function. Thank you.